Let's bring in criminal defense attorney and federal litigator Vikas Bajaj. Vic, great to have you on. So it looks like we finally have a crime. Jonathan Turley writes the following, quoting here, "This is becoming a three-card Monte game on where is the crime. Up until now, dozens of references were made to state law violations. However, the unlawful mean is now being cited as federal election law violations in making an unlawful campaign contribution. So it's a federal election violation in the state of New York." I'm confused. So are a lot of people, Vic.
For good reason, Trace. And so the federal violation in and of itself has a longer statute of limitations. If the goal of that conspiracy or that mental intent for the criminal act is there, then misdemeanors or any other potential criminal acts can bolster the felonious activity. It really is a situation when you're in law school and your professor says, hey, can you find a crime here on this set of facts? And at the end of the exam, the professor says, that was cute, but that's not the way it works in real life. Here we have Judge Merchan saying that's cute, but we're going to let it fly.
Yeah.
And that's the scary thing for any attorney. I'm a defense attorney. Prosecutors as well would like to have clarity, and you can bet your bottom dollar that jury, after sitting through a full day of arguments, is asking themselves, hey, where's the beef? Where is the beef in this case?
It's unbelievable. Judge Merchan, a lot of the analysts we saw in the courtroom kneecapped the defense. Trey Gowdy says the following, quoting here, "Prosecutors are feeling emboldened and unthreatened to do whatever they like. There is really no fear of being ruled against or otherwise sanctioned by the court, but the jury doesn't know that. They must believe all of this is legitimate." I mean, and it seems like there were few rules for the prosecution, a lot of rules for the defense.
This is one of the intangibles of jury trials. A jury believes defense attorneys and prosecutors are treated equally until the case starts. When you have a judge that is biased, and there can be no measure of disagreement about that fact in this case, and the defense is constantly in a position of justifying their actions, having objections made when they shouldn't have otherwise been sustained, it sends a message to the jury that the prosecutor is right and the defense team is wrong, and therein lies the biggest deficit with that type of ruling.
And Andy McCarthy writes, basically, we have spent 5 hours here so the prosecutors could dizzy the jury into believing there are oceans of evidence. As it washes over the listener hour after hour, you easily miss that there is no evidence of Trump's participation in a crime. Your final thoughts?
In every jurisdiction, a judge will give a charge to the jury instructions. This is what you use to evaluate the evidence. One of those is what the attorneys say is not evidence, just discount it. So really the jury wasted about 8.5 hours today, but when you have a closing argument of 5 hours, 4 hours, something to that effect, unless it's a serious federal RICO conspiracy, including 50+ witnesses, which this case is not, there's one guarantee: you're going to lose the jury, and hopefully for Donald Trump, that's the case here.
Boring is what the caption read on Truth Social. Vikas Bajaj. Vic, thank you so much.
Thank you.